Thank you to all the speakers who are here. We already have a question? All right.
Yeah, I have
Let's
a
go.
question.
Let me bring it to you so we get it.
It's not unusual to get the letter from the attorney or looking through the medical records, and you'll see in the application to adjudicate maybe 12 body parts or a whole bunch of stuff that's listed. The patient or the applicant comes in, and you get their response to what the problems are. And maybe out of the 12 that were listed, they mention maybe 4, definite 4. And as you're doing your exam, maybe 6 show up. At least you're describing what these conditions are, and you're putting it in your report. The question is, what is our responsibility for those others that didn't apply, don't even seem to be part of the case, but the attorney had put it in that application to adjudicate? And besides responsibility, will that be calling me in for a deposition if I'm not responding to those others?
I think it's astute that you noticed that. Let me point out a couple things. From my own experience, when someone comes in to see me and they describe an incident, sometimes I'm not sure if it's a neck or a shoulder or an elbow. And practically speaking, I can't even get a doctor on an NPN to look at something if it isn't pled, at least to start. So sometimes we end up over-pleading the case, and then it boils down to be just the neck, for example. So I would, in response to your question, I would say 2 things. One, you can acknowledge what you saw in the application. Down the road, now you're looking at the advocacy letter or the letter from the parties. It should say, we try to have it say, what's accepted, what's in dispute. If my client is still complaining about things that have been denied, I will usually put in the letter, and please also evaluate and address these parts that have been denied and advise if you find injury. So I would look to the letter next to see. And then I think in summary, to prevent maybe a needless deposition, you can acknowledge what you saw in the application, what you saw in the letter, what you saw in your examination, and these are your conclusions. And I would, talk about all 3. Anything to add, Jody?
Not much to add except for that, yes, you need to pay attention to the advocacy letters. And because each of those parts of body I have to deal with at some point down the line. Because although they're pled, when we go down to settle it, it's going to be based on your opinion as to whether or not they actually sustained an injury to those parts of body. So the manner in which we settle, for instance, if it's a compromise and release, we put in all the parts of body, but there's an alternative way of settling workers' compensation cases, which is called a stipulated award, where we actually have to identify the parts of body for which you're going to have future medical care. But we also have to indicate, if you didn't find injury to certain parts of body, that we would be dismissing those parts of body. So every part of body needs to be addressed by the medical practitioner, the medical legal evaluator, and needs to be eventually addressed by us in the long run.
I would add 2 things. Jody, when she spoke, made mention of the importance of the applicant's deposition. In preparing my client, I try to get them to be sure to describe everything in the deposition that still bothers them, and the defense attorney, a good one, will make sure to clarify what are the parts of body they're still having issues with at that time. So that's just another resource to seek clarity. I try to plead the cases pretty specific, but you might get a pleading that just says upper extremities. And it's going to be on you to figure out what that means. So thank you. I try not to do that because it doesn't really do anybody any good. And I want to be more clear, more concise than something broad. If I really don't know what the heck's going on, sometimes I have to plead it that way, and I'll let the doctors figure it out because that's what we need them to do.
Any other questions?
I have a bunch.
There's a 4th. Let's start with 1.
Yeah. Dr. Cocchiarella, first, the DRE Category 3 lumbar spine. I got deposed on this actually this week, and they wanted to say, does an injection count as surgery?
No.
No? Okay. That was simple enough. And then on page 427 of the guides, figure 1519, where they break up each segment of the spine into percentages. What's the application of that?
I know what you're referring to. Actually, I don't even have got a copy of the book there. I could see easily.
You need to.
Yeah, that would be great.
And the only reason I ask is because I literally got deposed. What is Dr. Cocchiarella's opinion of the reason for this. I was like, I'm not sure, maybe you should ask her.
This, I believe, was the carryover from the 4th edition, and I'm just looking to, yeah, basically, it's used to kind of do a conversion, you know, as it says here under the range of motion method, whole person estimate being converted to a regional impairment should be divided by 0.8 for the cervical spine, 0.4 for the thoracic, for the 0.9 for the lumbosacral spine, and then they give an example here. So they're basically telling you what the equivalent, if you had a DRE method, and you came up with a particular rating, then what that would mean if you were converting it over to range of motion and looking at the particular regions. So it kind of outlines here what it's used for. I mean, in terms of how it was originally put in here, from what I recall, I believe it was something that was in the 4th edition, and the reason that this was even being asked of the AMA was because they were asking to try to help determine if someone had an overall spinal rating, what the equivalent would be for the whole person, because they wanted them to be able to kind of look at both whole person and also look at kind of a regional value. So this was designed to be able to look at regional value and understand how that relates to the overall whole person value. And that was the reason for it.
But does that ever come up anymore?
I think it comes up where people try to use this and say something like, you know, he's got basically the lumbar spine is worth 90% of the whole person, and then they've tried to use that to actually give like a higher whole person impairment rating, and that's where it's been misapplied.
That's exactly what I said. I was like, I don't think she intended it, well, not that you wrote that, but
Right.
to artificially raise the impairment of the...
Yeah, no, it's been misapplied in that way, but the
Yeah.
original intent was to basically see, you know, how the regions relate in terms of overall spine and overall whole person.
Okay.
Just on that point, am I correct, Dr. Cocchiarella, that I thought that there were other states in the United States? Because, I mean, obviously AMA Guides isn't only used in the state of California. So as I understood it, and correct me if I'm wrong, that there might have been other states in the United States that were looking at use of that for other purposes. Have you heard of that before?
They've used it in terms of trying to identify kind of a regional impairment, like not a whole person impairment. And so they've used it for that purpose, but not taking the actual percentage values there and using them as the basis for the overall rating.
Correct, and I believe that there's a case, I think if Adam might remember this, it Torrey Pines, I think it was, and it was a particular physician that tried to perform the percentage assessment to increase the whole person impairment by doing some type of multiplication off of this table, and the court said, no, we weren't going to permit you to do that.
Yeah, there's actually multiple cases on it, on table 15-9, and they go both ways. And they're not, the doctors were, I'm not weighing in on whether it's appropriate or not, or accurate or not. I can just tell you what the cases say. The cases clearly acknowledge that that is not the strict rating for a spine, and that under a Guzman analysis, the court has bought various physicians' analyses. The ones where it didn't, the doctor didn't explain it, they just cited it and did some math. I think, personally, when I explore spine issues under a Guzman analysis, I don't go there, but there are some cases reported on it. And they're not what we call precedential cases, they're just sort of first-line cases.
Right, so I guess just to summarize, in answer to your question, you know, if they were to ask me why that was here, basically it's here because this would enable you to take a whole person impairment and convert it into a regional spine impairment if that was requested. but that's not how things are done in California, but it is how things are done in other states.
Okay, that makes sense.
Any other questions? For next question? Yes.
So if you have multiple disc bulges, protrusions in the lumbar spine, and the patient has subjective symptoms of radiculopathy, but there are absolutely no objective findings, EMG, NCV, sensation, motor strength, reflex, everything's normal, you're stuck with DRE 2. In the cervical spine, from my reading, it's been pointed out that for the same circumstance, you can push it to DRE 3. Is that correct or not?
And they're doing that on, it's the actual table.
Page 392.
While she's looking to answer that question specifically, just parlaying off your facts a little there, Dr. Gross, about the multiple disc protrusions in the same spinal region, the guides is inconsistent with respect to when range of motion might apply under that circumstance if there's no other evidence of radiculopathy. Because there's language on that page that seems to suggest you have to have more than that, and others it says you don't. I can just talk about reported cases. What you got there? Oh, come on up. Oh, did you, your point, okay. There are reported cases that accept a broader applicability of range of motion versus DRE when there are multiple disc protrusions in the same spinal region without some of the other elements. That wasn't exactly your question, but I like the facts, so I took it where I wanted to go with it.
Yeah, I would still be putting that person under DRE 2. I'm not sure under what criteria they were actually putting them under DRE 3. Do you know for cervical?
No, but I did propose, how come you should put them in 3 and have
Yeah, no, the appropriate interpretation is, if they don't have the objective findings and you can't identify anything on your clinical exam that would really, substantiate it further in terms of, atrophy or any other sign, then really you need to put them in DRE 2.
Next question? Right here.
Let's say you have somebody that has symptoms of carpal tunnel. They have positive clinical findings, strong 10Ls, Phelan, digital compression. But their NCV studies are normal, and they have 2-point discrimination that's normal. And let's say they can't work because they just can't handle the pain associated with it. What impairment can you give them?
Who's getting this?
What was the question?
Carpal tunnel that's not verifiable symptoms, not on an EMG.
Right, so basically you've got a case of an individual who clinically has symptoms, but you said in terms of your clinical findings that they didn't have any sensory deficit and they didn't have any motor deficit, and the EMG and the nerve conduction studies were normal.
They have strong 10L sign.
So it's almost like an exertional,
Right.
almost an exertional carpal tunnel, almost. That we, as an ortho guy, we've operated on a few of those.
Yeah.
One of our recommendations would be go and get an EMG after you've typed on a computer or done something to aggravate it for 2 or 3 hours and get the EMG right after that. And that's one thing you could try. But there is a thing that exists, exertional carpal tunnel is real.
Right, so that's a very good point. Did everyone hear that response about, sometimes timing of the study? In terms of what I've done in situations like that, if you really do believe that the person does have carpal tunnel syndrome, it does say in the guides in that section that that EMG nerve conduction studies can be falsely negative, in about 5% of the time. And in that sensory section where you would actually rate the nerve changes, one of the options for the very first rating is that the individual can have some sensory symptoms. So, you could technically rate them and say you think the nerve conduction studies are falsely negative in this case and basically make a case for it. So that would be the other option. You could go either way, I think.
In California, you can do a Guzman analysis and try to find an alternative table or chart that talks about how the upper extremities are impacted in use of ADLs, and you can do it that way, justifying and explaining it. It still may end up in the same place as Dr. Cocchiarella's recommendation, maybe a little bit more.
Yeah.
It can't be zero because it's impacting their ability to function, and there is some alteration, as usually identified on the clinical examination, of the use of the hands and wrists.
Yeah, and I do think that this section here, for example, sensory deficit, distorted superficial tactile sensibility, diminished light touch, with or without minimal abnormal sensations or pain that is forgotten during activity. So, I mean, if an individual basically gives me a history that's very consistent with carpal tunnel and you believe that that is actually the case, I think you can make a case that under this, they would have some sensory changes that are experienced, for example, more so in the night or upon awakening, and so you would meet the criteria. That's on page 482.
What page are you referencing?
482, that's table 1610.
There was one case I wanted to talk, I don't know if there's another question out there, but if I could, there was a case I meant to mention in my presentation that might come up on deposition more recently. It's an offshoot of the Guzman. It's called the kite case. I'll talk about it in a second. I want to follow up on a statement that Jodie made because I couldn't rudely interrupt her from the audience until the end. Just about the Alvarez-Guzman. It's really the Guzman. There was two cases, but so people call it Alvarez-Guzman, but the case that ultimately became in law in 2013 was Guzman, that allows for an alternative approach to a strict rating from the guides, which probably makes Dr. Cocchiarella shudder, but we're a little crazy here in California. So, but I don't necessarily agree that it has to, that extraordinary is the standard. I think that's been shot down by case law. But I do agree with what Jodie said. It has to be considered, and it is not applicable in every case. In most of my cases, Guzman analysis is not applicable, and the guides in and of themselves are sufficient. But one of the offshoots from Guzman, and physicians don't necessarily recognize this because they don't deal in this part of the playground, is that once you give us the impairment rating, it's adjusted by California law based on age, occupation, and the 1.4 modifier. And the Guzman case says that we can rebut any part of that rating string, which includes the combined values chart. And so the kite case stands, has anyone been questioned about the kite case? One. Anybody written about the kite case that hasn't been questioned about it? Anybody see it in an advocacy letter and be like, what are they talking about? Okay. So the kite case, the proposition is pretty simple. It is an extension of the Guzman analysis. It says that in some cases, essentially if there's a synergistic effect between multiple disabilities, that the doctor could explain how and why the disability should be added at the end of our rating string instead of combined. So 2 10s combined is an 18, 2 10s added is a 20, to give you an example. And if each percentage point is about 3 weeks, it's a difference of a couple $1,000s. So in some cases, it doesn't come up, it doesn't move the dial substantially. But if I have a case with multiple rating strings and I'm 68% and I think the person's pretty messed up and I want to try to advocate to get them at the 70% or higher, kite is a question that I might ask you to consider. It's completely valid under the law. The courts have found it applicable in some cases and not in others. And more often than not, it comes up in the context of, I see it mostly in extremity cases, on occasion if there's multiple spinal regions that are affected. And in some cases, I've had non-orthopedic examiners talk about adding the disability because of multiple specialties, psychiatry, internal medicine, and orthopedics, because the person's functioning is so impaired. Last point I'll make on this, again, often it comes down to money. That's the issue that we're fighting at when we're trying to resolve when we get to the point of the impairment analysis and the rating string, is that the combined values chart, which was directly incorporated, except for a typo, in the 2005 rating schedule, makes it near impossible with a strict rating of the guides to get to 100%. Impossible. I can think of one example. If you are rated 85% for being wheelchair dependent, times 1.4, you're 100%. You could have 20 different rating strings, a 10, a 20, a 40, a 30, a 20. They're all going to combine to 86. I mean, it's just impossible. And oftentimes, those are the most significantly, an injury to anyone is important, and it affects their life, whether it be a pinky to multiple problems. But there are people that have significant multiple disabilities, and that's where the law fails them. That's where the legislature failed them by not being more considerate or affording other exceptions when the combined values chart impacts that person getting the full extent of their permanent and total disability. And the last thing I'll say, again, because it is money, someone at 99% who's 55 years old and is a maximum earner, the case value might be somewhere in the range of $500,000. Someone who is 55 years old and is permanently and totally disabled, it's probably 3 times that amount. So the stakes are big. Any comment? Thank you.
I have a question I'll read here. This is about a case. So an applicant has a continuous trauma injury. They're injured as a food service worker, and it involves several body parts, including the neck and low back. The worker has a prior award from 5 years earlier with a compromise and released, and it lists the award but doesn't list a final report, and it does not list the MMI status. It doesn't list any impairment ratings for the neck or the low back. What are your suggestions for apportionment of the current injury? Anybody want to take that? Okay. Got it?
Unfortunately, this is a lot more common than I'd like to say, because I don't know about you, but I'll go back and I'll ask for the pre-existing records. I'll ask for the prior case settlement. I'll ask for the prior medical records, and I don't understand why we can't get them. Maybe the attorneys can address why we can't get them. But these are records that should be accessible, that were available within the last 4 or 5 years even, or even on a prior case. But what I would do is, if I absolutely could not get the records, is I would look at what the pathology is at the point of time that I'm evaluating them, look at what the prior injury was, and then try to make an assessment based on the prior injury, what the rating would have been at that time. So if you're rating basically based on, the back, well, what kind of DRE might you have given them back then? If you're rating based on, for example, the knee, what degree of arthritis do you think they may have had back then? And get an idea about what sort of treatment they had, what the prior injury was, and then basically do some degree of apportionment for what the prior injury and rating would have likely represented, looking at today's methodology.
I think Dr. Cocchiarella's approach works probably in other jurisdictions than California, up to the point where she said that she would estimate what the rating would have been, because there is a case that said that's not consistent for an apportionment determination. They don't want people throwing out previous impairment numbers without it actually being sort of contemporaneous to the prior injury. But that's not to say that there isn't apportionment in this situation. And to the point where you suggested I could look at the underlying condition, the diagnostic testing, and I can indicate that some of what's there that's directly causing the present permanent disability could not have been from the most recent injury, that would substantiate your conclusion. But for some reason, the courts get a little funky about comparing impairment to impairment, because I don't know. It's all a fiction. I can't explain to you why, but that's what one of the cases says. But you can get there another way if you have the evidence. And I'm going to pass it to Jodie because she's got to track down the records if she really wants to substantiate it and justify it.
True, I do have to track down the records to substantiate it. I agree with Dr. Cocchiarella, actually, and that's why lawyers exist, and that's why Adam's sitting where he's sitting, and I'm sitting where I'm sitting, because there are other cases, and I'll just throw this out for Adam's sake, Brody and what we call Fuentes Formula A, and the subtraction that occurs under 4664, again, is my burden. What that means is that if, and I believe this can be substantiated, if we get the medical records and Dr. Cocchiarella's approach can be proved up and can be substantiated based on the objective findings of that underlying injury, and if the medical records can substantiate, time is taking its course. In other words, that you didn't give me any timeline, for instance, in this hypothetical, but if the medical records allowed for impairment assessment by use of the AMA guides, then you're talking about an apples to apples comparison. What was the impairment that was relied upon for the underlying settlement is easy. And as time goes on, you're really in a situation where it's the AMA guides versus the AMA guides. Where it gets more complicated is where you've got awards or CNRs that are based on work restrictions, the apples to oranges. And then my burden at that point is to go to a medical practitioner such as you and to take a look at the medical records if we can get them. And then I walk you through the process to determine if you could render an opinion as to what their level of impairment would be under the AMA guides. Granted, there are cases that challenge this approach, but there are equally other cases that allow me and the defense, at least the defense bar, to substantiate that underlying impairment to provide a different assessment of apportionment. So your percentage of apportionment may not necessarily be applicable because there's other legal standards that the court could use to determine how the ultimate disability will be determined, and that's called like Fuentes Formula A.
So would it satisfy both the sides if, for example, the approach would be to assess, for example, the lumbar spine and look at what the pathology was like and what the symptoms and disability were like at the time of the original injury based on what the claimants told you, and then look at what the, for example, knee findings were likely have been based on what the claimant tells you the injury was, and then trying to basically say, okay, well, given the natural history of those conditions and their progression over time, and then a subsequent injury, I'm going to apportion, say, 40 or 50% to the initial injury because of the likelihood of arthritis and progressive arthritis, and then 50% to the new injury, or whatever percentage you decide to use. If you basically phrase it in those terms, is that language that both sides think would be more appropriate?
Who wants to bet that we're going to agree on the answer?
I think she should be sitting between you.
You're on a path of analysis and you are giving your medical opinion. The law is probably going to question some of the speculative nature of your analysis regarding the progressive nature of the issue. The other thing is that since the guides weigh so heavily on ADL impacts, in the law, on the flip side, doesn't believe one can rehabilitate themselves from a previous disability, whether it be under 4664 or 4663 probably. You'd also have to explore how the person was impacted in the timeline, again, back to that timeline between the first and the second. If I give you an example. I had a gentleman who had a bad injury, and he was in the hospital post-spine fusion, and he tripped over the IV bag stand coming out of the bathroom and injured some other parts of his body. that had previously been injured. And an apportionment issue arose related to, say, his knee. And there were records from a prior knee injury showing that he had knee complaints right up to a month before his industrial injury. Now, initially it didn't matter because we weren't claiming his knees in this case, but then when the knees became an issue, there was pretty good apportionment to the prior stuff because he had symptoms and it was impacting his function right up until the date of the injury. So I would add those considerations to be thought about. Then you have to look at, I wouldn't call it rehabilitation, but you look at their ability to function in the workplace as well. They had a pretty sedentary job over time, probably not a consideration. They went back and they were doing something physical for a long time between the first two injuries. It's a consideration. What you do with them is your considered opinion.
I would say that you're definitely on the path to bolstering your opinion. I mean, based on your clinical judgment and your expertise in an evaluation of the individual's objective findings, potentially from diagnostic studies, would be able to substantiate your opinion for the apportionment. Because again, the way that the law is written now, my clients are only responsible for that percentage of permanent disability that was directly caused by the current injury. Now, granted, I think we all agree that there is a certain level of speculation when it comes to apportionment. The judges, I think, even accept that as well. Where they're discounting your opinions is when it's conclusory. So if it can be bolstered in the manner in which you're describing, based on earlier medical reports and the pathology, and you can describe the medically supported, studies regarding the progression of certain underlying pathologies, then I think that that's something that I can argue to a judge that would be reliable as substantial medical evidence.
Any other? You got one? Good. Okay. You're easier to get to.
Thanks. When you were talking about using the combined values charts or adding them, where does 4662 come into this?
Thank you.
So Labor Code Section 4662 deals with permanent total disability. And there are a couple of enumerated conditions: lack of use of both hands, blindness in both eyes, where you are conclusively permanently totally disabled. And then there's a subsection, B, that talks about in all other cases according to the fact, which I think you're referring to, correct?
I deal with a lot of brain injuries.
Yeah. I mean, if it's a brain injury, you can rely on the incurable mental capacity subsection, which is under 4662A, which is conclusively presumed, so none of these issues matter.
So then the values charts have really no meaning with that.
Zero meaning is the answer to your question. And I just read a report this morning, because why not work? I'm working Saturday anyways, why not, right? Have a gentleman who had a stroke, a firefighter, and the neurologist initially weighed in and asked that his speech be evaluated by a speech therapist, and they did that, came back, and he has significant speech impairment, which emanates from the brain result of the stroke. So in his supplemental report, he said, I'm now reconsidering my conclusion. I do believe he qualifies for the conclusively presumed permanent total disability under 4662. Prior to that, I had scheduled his deposition, and I was going to question him about kite, because despite all of the multiple disabilities, this firefighter who has paralysis on one side, can't find words, and has a number of other consequences from the stroke, it still didn't equal 100% under the combined values chart.
You could have likely just get over, maybe over 70.
Yeah.
If you use the, in fact, in chapter 13, at the beginning, it says you have to take the worst impairment, and that's the one that you use.
Correct.
And that's totally ridiculous, because in the nervous system, each one stands by itself.
True, and that is,
Very low impairment.
and in chapter 13, that's where Guzman can kind of come and sort of be really applicable in those cases. Because to me, the question is very simple. It's twofold. The point you made, does this other impairing factor, is it separate and distinct from the other element? Yes. And in this particular case, is it impairing the individual specifically in a different manner? Yes. So it wouldn't be accurate then to not include all of the impairing factors if you're assessing this person, correct? So again, these are big injuries, extraordinary circumstances, not applicable in every case. But the simple answer is if it's conclusively presumed to be permanent, totally disabled, the combined values chart is irrelevant.
This question is for Dr. Cocchiarella. On page 380 of the guides, figure 15.4, you got the flow chart with the DRE and range of motion method. And then below that, there's a section, 15.2a, it's a summary of specific procedures and directions. And it carries over to the next page, number 7 specifically, I had a question on. Where it says, if more than one spine region is impaired, determine the impairment of the other regions with the DRE method. And then it says, combine them using the combined values chart. So I guess my question specifically is, does that mean if you have more than one spinal region that you're not to rate more than one with the range of motion method? That automatically the additional ones are supposed to be done by the DRE method? And if that's so, what do you determine as the primary? I mean, someone can injure their cervical spine and lumbar spine equally, especially with cumulative trauma type of situations. Which one do you pick to do the range of motion method if it's appropriate in that situation?
That's a really interesting question. In fact, I've never heard it before.
I've heard it come up in deposition.
Uh-huh.
I would say a couple, if I understand, can I just restate the question, make sure I get it? Sure. If there are injuries to multiple spinal regions and you're trying to determine which one to apply the range of motion versus the DRE to the others, is that?
I was looking at it differently.
Yeah, well, that's
So,
part of the question.
that's part of it, yeah. I mean,
Part of the question.
I think you're asking if they have a legitimate, which I think it's, well, maybe it's not that real, but if they have a legitimate range of motion injury, say to the lumbar region, and they also have a legitimate range of motion injury to the cervical region, then under those circumstances, the way it's read here, it's basically implying or stating that you would use the DRE method for one of those and the range of motion for the other. But I think actually it would be more appropriate to use the range of motion for both, assuming both actually qualify for a range of motion analysis. I mean, I think because the guides say that, you can, if you can't use the DRE, then use the range of motion. I think in that case, you could make a very good argument and say, both of these have multiple injuries within that unique spinal region. There's 2 injuries in the cervical region, and then they have 2 injuries in the lumbar region, and they both qualify for range of motion assessment. I think you could make a good case for that.
I would say the doctors I've deposed on that issue, they agree that a strict rating of the guides is you can only apply range of motion to one of the 3 regions. And in a few rare cases I've had where those circumstances have applied, they've used Guzman to say they thought it was more accurate to do the range of motion in a second region. I've seen it done, again, rarely, usually pretty significant spine injuries. And how they've applied it is, because I think the guides in Chapter 15 is pretty consistent. If there is a higher way to rate it for the injured worker, that's the way it gets rated. So, for example, if they had a fusion in the neck and the back, the neck DRE may be much higher than a neck range of motion, but the lumbar spine range of motion will be higher than the lumbar spine DRE. So, probably a considered physician would give you everything, explain why they think it's more accurate, and then let us sort of figure it out.
I know that there's latitude, but I was curious what the intent of that particular paragraph was.
I think in California, you got to go Guzman if you're going to break out from the strict analysis. I read it to be pretty strict. I'm glad to hear Dr. Cocchiarella thinks there's a little room in there, but I read it to be pretty strict.
This is on page 381, point number 7. Yeah, I actually, I don't rate it, I don't have it quite as strict, and I think that the overall interpretation of it, I think you'd be fine with range of motion in both.
Yeah, thank you. Good to know.
I have an applicant, during the course of work, he was moving light boxes, and out of the blue, he developed a Dupuytren's contracture over the fourth finger. It happened during work, but there was no insult, there was no trauma to predispose it. Reviewing the medical records, like 15 years prior, he had, I think, a crush injury to that hand and that finger. What's your opinion on apportionment or causation?
So addressing causation first, I think that in addition, I think that his work from the little bit that you've described, could be certainly a contributor to like a constrictive tenosynovitis or to some type of triggering if there was some repetitive, finger flexion work. And I'm wondering whether the person has some underlying conditions like hyperglycemia or prediabetes or something that basically is predisposing them to that. Regarding the apportionment aspect, I think that I would look and see whatever history I could obtain, not only from the claimant, but from the prior medical records to indicate that to see if there was any other interval problems with that hand. Was the original crush injury, how significant was it? Were there any fractures? If there was some significant anatomic abnormalities, then I would say, well, I probably would look at some apportionment. If, the crush injury was more soft tissue and there didn't seem to be any intervening problems over the years, then I would say probably apportionment wouldn't apply. I'm not a hand surgeon. I don't know if there anyone in the room is, but based on the similar cases I've seen or been asked about, that's typically how I would approach it. Did you have some other question pertaining to it, or other?
Well, it was moving light boxes.
Uh-huh.
Little microprocessors. So these electronic units are packaged really light and a lot of foam. I would think that it just happened at work. Like if he was driving home and it would happen, then that's when it would happen.
Right, but is it one instance, or has he had ongoing? Oh, so he hasn't had ongoing symptoms of it. He hasn't had ongoing triggering. There's no constrictive.
Not CT. It's a specific injury on that specific day.
But the person's still complaining of symptoms.
Yeah, on examination, you could see that there is some tendinitis, some contracture.
Right. So.
It doesn't really limit range of, there's some limit of past range of motion.
Mm-hmm.
It doesn't seem to affect rib strength.
It's sounding to me like there's probably some type of deficit there, and if they're doing work over a long period of time that require fine manipulation, that.
Sure.
Yeah.
I see gross manipulation. I don't see
Is
fine
it?
manipulation.
Yeah. I don't know. I in that case, I normally too go into the prior history of occupations and find out, well, what else was the person doing? Because you'd have to wonder what is predisposing the individual to this type of event, and was there some other injury?
Well, two things actually. So obviously Dupuytren's very hereditary alcohol, we know that. But actually, your longest finger in flexion is your fourth. So you flex your hand down, 4 is the longest. It is clearly involved in grip. So the issue, there'd be some apportionment likely to a hereditary component and certainly his current job, but the history, as long as he worked in between, well, I don't know if I would apportion to that prior injury in the past. If he worked for a long time, did his job didn't have problems, I probably wouldn't apportion to that.
What if he had a significant prior injury?
Okay, so then so a fracture still, you'd be more concerned about scar tissue, but still going to some other people's, if he did a very strenuous job for a long time and didn't have complaints, boy, you really have to go back and find those records, or as the old story goes, you're speculating as to what it was.
Any other questions? Yeah.
Sorry, I got a couple really simple procedural questions, which I thought I was comfortable with, and now they've been coming up. But I've been having a lot of advocacy letters that want me to send my reports to the WCAB, even though it's a represented worker, and I had never really done that before. And I feel like it's just the attorney being lazy. They don't want to print it and post it. I don't know.
There was an old regulation that mandated it. It doesn't exist anymore, I don't believe, so you can disregard it.
Okay, I thought am I right that if it's permanent and stationary, we should send it to the WCAB?
No, I think if they're unrepresented, you have to send it to them.
Unrepresented, yes,
Right,
but
if
this
it's
is,
represented, you can send it to the parties. Frankly, the workers' comp board is understaffed and they don't want extra paper.
okay. Issue on temporary disability that came up in a deposition. I saw the patient as a QME approximately a year after he was released. And when I did his temporary disability period, I said that it ended when I saw him. The attorney argued that it ended when the PTP released him and said PNS, and I said, well, that's a good point. Yes, that would be true. Am I correct in that? It's whoever says it first, right?
No, it's not who says it first, it's what your opinion is as to
Okay.
what it is. Although I would say in a lot of cases, it's pretty common to just concur with the treater because it makes sense.
Yeah.
Although there are some circumstances where it may not, and we can come up with a bunch of them, but I think you just need to think about it. I think from my perspective, the thing that drives me kind of nuts is the doctors will comment on, well, typically, there'd be TTD, post-surgery to the shoulder, 6 weeks, and then 6 weeks of temporary partial disability, and by then they could go back to regular work, yet the person was off work for 8 months because they couldn't get the stuff authorized. And there's all these other reasons, maybe in this particular case, the person had a frozen shoulder, whatever it was. And then it just creates a dispute with us, even though there's some case law that says that you can't make a retroactive determination, but what helps the parties on that issue is if it makes sense and it's the treater and the person's back to work, that's probably a good idea. If there's some other circumstances that would require a different opinion, I'll figure this.
Okay, yeah. Oh, sorry, one more. I was always under the impression that we were never allowed to review records that the applicant brought to us directly. And now all of a sudden, they're bringing them in and they're saying, our attorney told us, bring everything and show the QM. Yeah, exactly. And I'm sitting there like, I can't look at it, give it to your attorney. And I just want to make sure that that hadn't changed because this just happened a few times in a row recently.
It has not changed. You are
Okay.
correct.
All right. Just want to make sure. Thank you.
Some doctors no, even unrepresented, they have to share the documents with the other side.
Yeah, you have to disclose it.
What if they're bringing in the actual MRI or a picture of the X-ray and you already have the report? Can you look at the picture?
If I'm the doctor, yeah, I look at the picture and I just deal with it because it makes sense. I mean, technically speaking, probably not, but I don't think anyone cares about that.
From the defense perspective, I wouldn't have a problem with that. I mean, why would I object to a physician actually reviewing a diagnostic study? It makes me look like an idiot.
Yeah, I had a question. There are instances where an applicant will actually bring a picture of their work environment, which I know that we're not supposed to be looking at. And I will say to them, does your attorney know about this? Yes, the attorney knows. Ask them, I'd like to get a copy of it. I'd like to have it entered. I'd like to get a picture of that. Never get the picture. And so I'm wondering, is that something that then I can request in the report?
Yeah, I would tell you to disclose, say, the applicant presented with documentation. I did not review it because it was unclear to me, because it didn't appear to me that it had been agreed upon by both sides. However, I'm ready and willing and available to look at this additional information. The applicant told me it was a picture of their work, and I think that would be a benefit to me to review. So I asked the parties to agree, and if they want me to do it, I can do it by way of a supplemental report. So you can acknowledge it. Because really we both want you to get to the, whatever information you need to make the best result. I don't have a problem with.
I have a problem if by chance you may have glanced at it, you thought it might have been significant, you render an opinion, and I agree with that, and you do need to disclose that information. But if it's something that I might know about, and I would have objected had I known or been provided sufficient notice by the other side. Because we do have to provide each other notice of information that we intend to submit to you, and we have the right to object to non-medical. So you're referring to a non-medical document. What if I happen to know that there's a particular document that somebody was circulating that is not an accurate depiction of the workplace, and you've rendered your opinion on it, and I would have had, and you said, but I want to get this because I'm not certain that the parties know that I've been presented with that, I might very well object and say, it appears, Dr. Cocchiarella, that you've relied on something that we might question, you know, and its authenticity and reliability, and therefore, because you reviewed it and it was ex parte, I'm going to ask if your report is stricken in your opinion, and I have to go get a new PQME. So yes, you need to disclose it, but I would just be very hesitant to actually render any of your opinions on something because you have no idea of the reliability of that document, especially when it's non-medical.
I have another case. We have an older lady who was working in a garment factory, ironing, cutting, post-termination. So the company closed down, everyone was fired, and then a CT claim. On examination, I'm finding that she has inflammation of the distal joints, and I'm suspecting some sort of rheumatoid arthritis. Prior medicals show some sort of thyroid issue. And so I'm recommending that she goes and gets lab test, rule in or rule out that. Assuming that it does come back with some rheumatoid arthritis, what's your opinion on causation and apportionment?
So, I had another case, a little bit more strenuous perhaps than that one, but of a tree trimmer who had rheumatoid arthritis and who also had osteoarthritis. And so I think that, I mean, certainly those two coexist. It's an interesting scenario because you can rate the osteoarthritis as possibly work-related, assuming they were doing a lot of cumulative trauma with their hands, and assuming also that they were more predisposed to arthritic changes because of their underlying inflammatory arthritis. So in the one case that I saw with the tree trimmer who had both osteo and rheumatoid arthritis, in that case I actually ended up rating the rheumatoid as industrial. And I did because there was so much trauma that the person had, and there's a significant amount of literature about how trauma can be an accelerator for the development of rheumatoid arthritis. So I think actually those are kind of two different areas, and one can be medical in terms of internal medicine, the other can be occupational in terms of, for instance, the OA. And then I think there's the apportionment issue also takes into account, for instance, the thyroid problem, which is probably a contributor to this as well. And so I would, be apportioning to that. But I think whether or not there was sufficient trauma to indicate that the rheumatoid might be partly industrial is a separate analysis. And I'm not sure if it pertains in that particular case. I thought it did pertain in the case that I was seeing, in which case the person had very significantly heavy trauma as a tree trimmer.
But in this case, it's post-termination, so she went and got all these, all these things after. Like, there's no medical records of any injury while she was there, and then prior medicals, just that are unrelated to work, show that she has an endocrine disorder, thyroid issue.
So, I mean, if the pre-injury medicals don't cite any problems relating to the hands, and they, then the question would be, well, is her case possibly a cumulative trauma case, over time due to basically repetitive fine detail work in terms of the hands? And certainly that type of work can predispose to osteoarthritis. So it may not have anything to do with the rheumatoid arthritis, but it may actually be a contributor to the OA. And it really would depend on kind of the work history. I mean, if she's doing a lot of fine work, sewing, basically sewing more so, involves grip, fine manipulation, maybe a little bit in terms of the folding and things that you mentioned, but if they're doing a lot of it, and she's doing it for many years, that has been shown to be a contributor to osteoarthritis. I mean, in terms of the medical literature. You can look up garment workers and see that they're at increased risk for hand arthritis. I mean, one of the things that I do is, I'll look up under the person's occupation, I'll look up under what the mechanism is, and see whether or not any of those are consistent with there being potential occupational causes. I had a question, sorry, I'm going to, because it's kind of following up on this. So if you have a claimant that comes in and you get an LOE that basically, letter of engagement, that indicates the person had a particular date of injury, and maybe there was some minor event that happened on that date, but the real injury was cumulative trauma, and neither of the parties have acknowledged or put in any of the letters to you that this is a cumulative trauma case. Is it best for you to address it as an injury and give your opinion on the cumulative trauma, or ask the parties whether you would like them? How should the cumulative trauma that the applicant gives you be addressed?
It actually comes up quite a bit under specific circumstances where before lawyers get involved. Because most oftentimes an injured worker will fill out the claim form, DWC Form 1, and say, my wrist hurts, I'm a data entry person. So when they fill it in, they put in the date of injury, December 1st, 2018. And so before a lawyer ever gets involved, and then if there's a determination of causation and you become the qualified medical evaluator, when you get the letter from my client, it's still going to have that specific date of injury. You're going to understand that that's what was alleged because you have an unsophisticated, applicant or injured worker who doesn't know that it's a cumulative trauma. From my client's point of view, at the initial stages, prior to litigation, it's your determination as to what injury the individual had. Was it a cumulative trauma? I think, and it's in my client's best interest, because once an attorney gets involved, they're going to do potentially one of two things. I won't necessarily, but I've seen it either way. They're going to go ahead and file it as a cumulative trauma, potentially. I've also seen them go ahead and file the CT and the specific. Sometimes they might only file for the specific, and why is that? Because my client had already accepted it as a specific, even though medically it's really a cumulative trauma. The attorney doesn't want to risk the possibility that my client might deny the CT because the specific was already picked up. So then when it comes to you, it's still technically pled as a specific, and your opinion would be necessary to actually opine whether it was a specific or cumulative trauma. So those types of things happen all the time, and it's usually just a matter of semantics because of the way that the injured worker had originally pled it. So I do appreciate, the other reason I appreciate is because I do like Benson. So if you happen to find a CT and you find a specific, then you can apportion to them and it diminishes my client's liability overall. So find more injuries, especially with my self-insureds. I primarily defend self-insureds, and so risk modification for insurance rates don't affect or apply to them. So more injuries that you have, it's not that big of a deal. It diminishes their exposure and liability and diminishes compensability. The actual monetary value to my clients. So I don't mind. Find a new injury.
So the statute that gets us to the medical legal evaluator talks about a dispute regarding injury. So I think legally you are on solid ground to address the mechanism that you've identified despite the pleading. Politically, and Jodie's much more practical, I've had other people sitting next to me on a panel that says you should never discuss anything you weren't asked about. I think that's very narrow-minded and short-sighted. So you have to weigh the political impact of the decisions you make and when you report. But legally, it's on absolutely solid footing, in my opinion. From a practical point of view, if the person comes to see me and it's accepted as a specific and I really think it's a CT, I have two options. I will just amend the specific to become a CT right at the onset. Or if I'm a little unclear, I'll try to put a letter in to the doctor that says it was pled as a specific. It put in my argument why I think it might be a CT. Please clarify for us. If you find both, now we're invoking a Benson consideration, and despite Jodie's love of that evil case, the exception might apply. As long as it's not Adam's case, give him a call. But yeah, you can see how that then takes us to the conversation we had earlier.
Thank you. Dr. Reed?
I have, it has happened to me 2 times. One time, the attorney called that he wants to be present when I'm doing the QME examination. And the second time, a call came that, can we tape record your QME examination? I want your opinion, what should I have done in both circumstances?
Yes and yes. The attorney is entitled to be present, and they're entitled to record.
With
He can be present?
No, with notice, yeah. Yes.
Both are one. Applicant and defense are only applicant.
Applicant, I mean, I've never tried to do it as a
I mean,
defense.
Never seen it as a defense.
I've never done it as a defense attorney.
I don't think
Frankly, I've
they
never
would.
even looked at it.
I don't think they're.
I wouldn't want to be there because of I would not want to be there as a defense attorney because I wouldn't want to have unduly influenced the physician or intimidated. I mean, am I intimidating? So, yeah, I wouldn't want to impact that. As a defense attorney, I wouldn't even do that.
So the applicant attorney is allowed to come?
With notice, yes. And you're entitled
Who
to
has time
record
for
too.
that?
Exactly, who would want
Are they allowed to video record or will they tape record?
video? I think I don't know about
I don't think
video.
there's
I think
anything,
it's just.
there's nothing in the.
The question is, what is the law? What is the law? Is the applicant attorney allowed to come with the patient?
Yes.
And the tape record, can they allow to tape record?
Yes.
Yes.
My only question with that other argument, specific versus CT, I mean, from your standpoint, it really doesn't matter regarding if there's only one apportionment, but one of the issues is if it's a CT, then the amount of time they have to seek treatment isn't that longer. That's one of the real advantages to a CT claiming that versus a specific.
No, there's no difference. And so, from a continuous trauma perspective, if there's no dispute as to the ending date of the CT, the liability goes back 1 year. Okay? So, in some cases, Jodie's, if it's not a self-insured, if there could be multiple insurance companies within that year, so they do want a CT to share their liability, right? From my perspective, I just try to keep it simple if I can, but the facts sometimes don't allow that to happen.
On a case on deposition, as they went through the deposition, the applicant stated they were in stress, and at that point they broke up, but they came back, and it was stated by the defense that if they were to pursue the stress claim, then they reserve the right to have a second deposition. Now it sounded like a threat to me, and I don't know what that is between the applicant. But the point is the patient or the applicant comes to me and still is expressing that they're under a lot of stress. I don't know to what degree, to what percentage that stress is. It's not for me to claim. It's out of my expertise. So I'm planning on sending that individual out for a psych evaluation, and we make that determination by that specialist.
Two things. Number one, when we're agreeing that that's not being pursued on the record, or we're going to do it another day, it is really just because there's a whole other line of questioning that are
He had
invasive.
dinner plans.
Yeah. Exactly. If it's not a pled issue, and you're seeing the person as a QME, let's say, you have to take a history of all the complaints. You should indicate it's not in your area of expertise. You're deferring it. The parties can figure out what to do with it, as long as it doesn't interfere with dinner.
Okay. We just hit our time, so let's give it a round of applause.